in Texas law. Now here's the big question for you. Should cases like this always get the maximum penalty, or does the court's discretion matter? Comment what you think below.
15 years to 99 years or life imprisonment with a possible fine up to $10,000. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Counsel, has your client been able to provide you with any defenses?
We have, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
We do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
He is and he was.
And counsel, you want to announce as well?
Sam Locke, with Ms. Chilkowski representing Troy Mishler.
Mr. Mishler, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
I'm so sorry.
So this is State's Exhibit 2, Your Honor, with the motion to seal attached. So that was just defense's copy. So this
All right,
is-
thank you. All right, we can, let me re-ask that question because the paperwork has been changed. Do you understand that if you were not a citizen, that based upon these charges and entering into a plea of any of these charges, you could be deported, not allowed re-entry into the United States, and denied naturalization? Did you understand?
Yes, ma'am.
All right. All right, everyone, if y'all could stop approaching, we're on the record, and I'm trying to focus on this. Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, the state is proceeding on counts 1 and 10. They're asking that your punishment be assessed at a cap of 30 years in the prison. There's a $5,000 fine and no applications. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions? To count 1 in the indictment, how do you plea?
Guilty.
To count 10 in the indictment, how do you plea?
Guilty.
State, any evidence?
Yes, Your Honor, the state moves to admit State's Exhibits 1 and 2 into evidence.
We've reviewed and have no objections, Your Honor.
All right, and with regards to the seal,
State's Exhibit 2, Your Honor, it does have a motion and an order to seal on that record regarding the content of.
all right, any objection to the court signing the motion to seal?
No, Your Honor.
All right, the court will find the motion to seal, which is a part of State's Exhibits 1, and it's listed as State's Exhibit number 2. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses? The state will call in the right to remain silent.
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments, and the court will review the same. All right, so what are we here for? Is this for a motion?
This is a motion to revoke probation, Your Honor. My client does intend to plead true.
All right, could I have the motion to revoke probation on this case, please? All right, court is calling 2024 CR 012861, State versus John Berry. Can I have parties announced?
Lauren Espinosa for the state.
Renee Munoz on behalf of Mr. John Berry.
And are you Mr. Berry?
Yes, ma'am.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes.
Are you the same John Cowan Berry Jr. who's placed on community supervision in 2024 CR 012861 for the offense of evading arrest detention with a previous conviction on February 27, 2025 for a term of 4 years?
Yes.
All right, state.
Yes, Your Honor, state is proceeding on violated condition number 41, which states on or about the 29th day of July, 2025, in Bexar County, Texas, the defendant, John Cohen Berry Jr., did then and there fail to comply with the rules and regulations of the felony drug court in violation of condition 41.
How do you plead to that, true or not true? And state, are you waiving the other allegations?
No objection from the defense.
All right, did you understand by pleading true to violation of condition number 41, the court could find it true, grant the motion, and sentence you up to 2 years in the state jail facility?
Yes, no.
Knowing that, do you still wish to plead true to violation of condition number 41?
Yes.
Court will find violation of condition number 41 true. Is there a proposed agreement?
Yes, Your Honor, the proposed agreement is to grant state's motion to revoke sentence to 2 years, as well as take into consideration clause number 2025 PF 29310.
Your Honor, we would just ask if we can just be heard in terms of the time of confinement with certain justifications related to substance use disorder.
All right, and the case that you're asking to be taken in consideration, what were the last 4 digits again?
29310.
And what is that offense?
That is possession of controlled substance, PG1.
All right. So are you in agreement with revocation?
Yes, Your Honor.
Okay. And then the court then will hear your argument with regards to sentencing.
Thank you, Your Honor. In terms of the punishment to be assessed by the court, we asked the court to take judicial notice on the court summary provided by probation that he did successfully complete lifetime recovery inpatient for the dates of March 14th, 2025 through June 30th, 2025, which he was issued a certificate of completion for that inpatient lifetime recovery. We do know, and we are aware that the court knows that he was subject to felony drug court conditions. He did suffer a relapse in which he self-admitted to felony drug court that he was using substances. So there's no dishonesty behind his issues, Judge. He did kind of fall off. He was at a sober living home, and then he did abscond from there upon relapsing. He did state reasons for doing so, where he was trying to get back to his family members that live in New Mexico. He did state that his grandmother is suffering from cancer, lung cancer. It's very serious, as well as mother that has diabetes. So there needs some help. We do believe that since Mr. Barry is not from here, San Antonio, he didn't have the proper support system. So that's why I think he's proceeding with this route, trying to resolve these issues, to get back to his family, to provide the support if they're needing, Judge. He hasn't been to state jail before, and this is my understanding is an evading arrest seconds underlying offense. So we asked the court to weigh all those factors and announce the punishment. We were asking for less than the 2. Judge would be asking for 10 months in a state jail facility based upon his issues with substance use. The fact that he picked up a new case is this possession case, nothing violent, and doesn't have a violent history, Your Honor. For those aforementioned reasons, we're requesting less than the 2 years.
All right. So the court is aware that this is a evading with on foot.
This moment right here shows the balance between accountability and compassion. The judge acknowledges the defendant's relapse and addiction struggles, but still sentences him to 18 months. Notice how she highlights personal responsibility. "You could have told the court," she says. It's a tough love moment that defines courtroom reality. Empathy doesn't always outweigh consequences. What would you have done in her place?
It's not in a vehicle. But also the court is noting that you absconded. That's a problem. And with felony drug court, I know that if you tell them what your issues are, they would have made arrangements with regards to any health issues your relatives may be having. Court is going to grant the motion, sentence you to 18 months in the state jail facility, give you credit for any time served, taking consideration 2025 PF 29310, and the court will give you credit for any successful inpatient treatment. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it? All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on community supervision. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that means, you'll need to speak to an attorney. Do you understand? And I'll also request the therapeutic community. I have no authority to force them to place you in the program. I can't order that. But they'll see that it's in the judgment that you need help with any type of drug addictions. It does not increase the length of time that you're in custody. It's just to help you with your addictions.
Your Honor, would the court consider presumptively granting him diligent participation credit upon him doing substance use classes, vocational and educational training in the state jail facility?
I will consider that once I receive it.
Yes, Your Honor.
Right. All right. So here's the thing, when you're released from custody, if you truly want help with your drug or alcohol problem, if I'm still here when you get out, I'll help you find a sober living house. But at the end of the day, if you continue the path on that, you're on, only one of two things going to happen. Either you're going to end up in somebody's prison or jail for the rest of your life, or either somebody's going to be identifying your body because the last time you use may be the last time you use. You understand? All right. Good luck to you. All right. The court is calling 2025 CR 00756-2B and 2025 CR 009816 State versus Kelly Gaggero. Could I have parties announced?
Jason Garrett here for the state, Your Honor. Amber Nader for the state as well.
It's Scott's for the defense.
All right. So off the record for a moment. So they don't have the W to signify waiver numbers anymore?
The clerk informed me at the last sitting, we did this, but they don't do that.
Okay.
Unfortunately.
All right. Just so I can know where we are. All right. We're back on the record. And cause number ending in 16, did you review the document entitled Waiver of Indictment, Reading of Information and Rights under Article 1.05 and 26.03 of the Code of Criminal Procedure?
Yes, ma'am.
And did you understand that?
Yes, ma'am.
Do you understand you have a right to have a grand jury hear the evidence in this case and make a decision on whether or not to hold you over for trial? Your attorney has certain rights. Also, the right for the passage of 2 days once he's presented with the information and 10 days to prepare for trial. Did you understand?
Yes, ma'am.
By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
In that cause number, the court will find that defendant has knowingly and voluntarily waived indictment, reading of information and rights under Article 1.051 and 26.03 of the Code of Criminal Procedure. Counsel, in each of these cause numbers, have you received all discovery and did you review it with your client?
Yes, sir.
In each cause number, the court will find that the state is in compliance with discovery. Miss, in each cause number, did you review the application for deferred adjudication or community supervision with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Did you review the court admonishments in each of these? I'm sorry, state.
Yes, Your
Just one moment. I'm just trying to find a document. All right, we're off the record. Defense, did you all get a copy of the information?
Yes, Your Honor. I think
All right, to
Gave
the
it to
clerk, so
the
I don't have a
clerk.
copy of the information.
She stepped out, Judge.
well, I don't think this is the original. I thought I gave them the
Could I
copy.
just see that and I'll hand it back
Yes,
to
ma'am.
you. All right, we're back on the record. Did you review the information in the cause number ending in 16 with your attorney? Did you understand it?
Yes.
Counsel, do you waive the reading of the information?
Yes, Your Honor.
And state you're proceeding on the information as presented?
Yes, Your Honor.
All right, and then in cause number ending in 62B, did you review the indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
No, no objection.
And each of the cause numbers, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
All right, and the cause number ending in 16, you are charged with placing a child in imminent danger of physical and mental impairment by having child in an environment with access to illegal substances. Here, our counsel. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility. If the court were to grant your application for deferred adjudication in that cause number, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. And the cause number ending in 62B, you're charged with possession of a controlled substance penalty group 2, 4 to 400 grams as a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison with up to a $10,000 fine. If for any reason the court were to grant your application for deferred adjudication, if for any reason that deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine. Did you understand? And each cause number, if you have a plea bargaining agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, sir.
And each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent. By entering into this pleas, you're giving up those rights. Did you intend to give up those rights and enter into plea bargaining agreements in each of these cause numbers?
Yes.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Gaggero, on each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No,
Anyone promised you anything other than the plea?
no,
Are you satisfied with the way you've been represented?
yes, sir.
Did you understand if you're not a United States citizen, then you could be deported, denied naturalization, and not allowed re-entry into the United States by entering into this agreement? Did you understand?
Yes, sir.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived her right to jury trial. In each cause number, did you review the plea bargain page with your attorney? Did you understand it?
Yes, sir.
According to the cause numbers, in one, your fine is $2,000. The other is $1,500. The cases will run concurrently. And there is to be a recommendation of deferred adjudication, and there's to be restitution to the Bexar County Sheriff's Office for drug testing. Did you understand that to be the plea in each of these cause numbers?
Yes, sir.
Defense,
Yes, Your Honor.
state.
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, sir.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, sir.
Counsel, are there any such motions?
So, Your Honor.
Outside the agreement, in the drug case, the state is requesting that your term be for 6 years. There'll be a TAP evaluation, 200 hours community service restitution, parenting classes. In the state jail felony cases, the state is requesting that your community supervision be for 2 years, 100 hours community service restitution, no contact with Layla Aguero, parenting classes, TAP evaluation, and follow all recommendations in the MRT. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, sir.
All right, then, and
There's a minor that was done, I guess, after here from the paperwork. As far as the no contact, what the agreement is now, because this was, I guess, continued from the last sentence for CPS record purposes, for us to do other than and determine what happened at the CPS hearing. So to make it easy, we are agreeing with defense that she can have contact with the children, but there just be monthly field visits for the entire 2 years of the perjury case. And so
why did y'all ask probation if they want to do monthly field visits?
I did, and it was indicated to me that that would be something they could.
All right. So they're asking then for no harmful or injurious contact with Layla Aguero. Did you understand those are recommendations from the state and the court does not have to follow those recommendations? All right, then in cause number 2025 CR 0056, I'm sorry, 7526B, how do you plead to count 2?
No contest.
And cause number 2025 CR 009816, how do you plead?
No contest.
State any evidence.
Regarding both cases, Your Honor, state off proven that evidence cases if one fellows have things.
No objection.
In each of the cause numbers, did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places? Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, sir.
Did you understand that today the state will be
And just like that, the judge defers guilt, giving the defendant one final chance under deferred adjudication. That means no conviction yet, but one slip-up, and it all collapses. Tomorrow's sentencing promises to bring it all full circle, especially with the co-defendant entering the picture. You do not want to miss how this one ends.
Presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony. Did you understand?
Yes.
And each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. And each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication in each of the cause numbers. So when is the co-defendant scheduled in this case for sentencing?
Tomorrow.
For the other one, for some of this one, we got reset for a week.
No, I mean, the one that, so this is a case where Suzanne Kramer is the defense attorney
That one's
Tomorrow.
tomorrow. All right, counsel, are you able to come back tomorrow?
I can, Judge. What happened, if the court recalls, originally I wanted it for that same day.
Mhm.
But guess it wasn't possible when we reset it.
Okay.
But if I need to come back, Judge, I'll come back.
All right, if y'all can come back, and what I can tell you, this is what I'm going to request. See if the CPS caseworker can zoom in, so the court can see what's going on.
I think the state can
Have the
make a profit, Judge, if they completed everything.
Here's the thing, in some situations, I don't like proffers, because people need to be on the record for what they have done.
Oh.
Yeah, so,
See if we can get this.
all right, and they can appear by Zoom.
Okay, that's fine.
All right, so we'll bring you back tomorrow for sentencing, and
Okay.
sentencing will happen on that day, all right?
Okay.
Once
Thank
you
you.
sign the reset form, you're excused.
Thank you.
You're welcome.